we appreciate y'all. Here we go. Okay, thank you. Welcome to the 5th District Court of Appeals. We want to wish y'all a good afternoon. And my name is Bill Peterson. I'm honored to serve with Justice Emily Miskell and Justice Ken Molberg. We appreciate y'all's. We've had to make a last minute kind of change of operations based on the inclement weather, but we really appreciate y'all's patience with us and accommodation of this alternate method of hearing the arguments in your case. And we look forward to you all's assistance in getting the law right in this case. And in the screen that's marked 5th Court of Appeals, there's a timer. Both sides, you may be well familiar with our timing system. The appellant gets 20 minutes, the appellee gets 20 minutes, and the appellant gets 5 additional minutes. There's no penalty for giving time back. But are both sides present and ready?
Yes, Your Honor.
We are, Your Honor.
Great. Okay. Well, then I'll go ahead and call the case. This is case number 0522-0855-CV, Garland Independent School District versus Reeder General Contractors Incorporated. Is everybody here on that case?
Yes, Your Honor.
We are.
Good. Okay. If you could, please identify yourself and your client before you begin your argument. Appellant, you may proceed as soon as you're prepared.
Thank you, Your Honor. May it please the court. Your Honor, my name is David Hanson. I'm here on behalf of the Garland Independent School District. This case is one that is on the topic of a breach of contract claim that was filed by Reeder Construction against our Garland Independent School District after the project was complete. There are 3 claims within the lawsuit. They can be broken down thusly. There's a claim for 5 potential change orders or proposed change orders, and I will go through each one of those. And Reeder is claiming that it's entitled to sue for breach of contract for those. They're not signed by Reeder, but that won't be the issue as to why they are not. The school district is immune from that claim. Reeder also asked the court to invalidate a liquidated damages provision so that Reeder can pursue a claim for the amounts that were withheld for liquidated damages under the contract. And finally, Reeder seeks to recover for damages for delay, money damages, based upon a damage that Reeder did during the construction project, and where its excavation equipment damaged an electrical feeder line that led to one of the renovation projects. So let me go ahead, and since this is a question about a waiver of governmental immunity, I'm going to go back a little bit to a provision that is in the Texas Constitution. And so as we're interpreting the waiver of governmental immunity under 271.152 of the Texas Local Government Code, we have to do that keeping in mind the constitutional provisions that are implicated by this claim, and specifically, this is a claim where a contractor is seeking to obtain compensation. So under that provision, it's Article 3, Section 53 of the Texas Constitution. And it simply says that the legislature shall have no power to grant or to authorize any county or municipal authority to grant any extra compensation, fee, or allowance to a public officer, agent, servant, or contractor after service has been rendered or a contract has been entered into and performed in whole or in part, nor pay nor authorize the payment of any claim created against any county or municipality of the state under any agreement or contract made without the authority of the law. So when we consider the scope of the waiver of 271.152, we have to consider that we cannot construe it as though the legislation was created in contravention of that provision. So it must be consistent with that. So to the extent that
Mr. Hanson,
oh, yes,
is it your view that all of the other intermediate appellate court appellate decisions that were cited both by you and your your colleague, that they just fail to, either the parties fail to appropriately raise, or they fail to appropriately consider Article 3, Section 53 of the Texas Constitution?
Well, to the extent that there would be any that would have allowed a recovery in this specific circumstance, and we'll get to it, because they may not have needed to have considered it based upon the claims that were made. But yes.
Well, I just want to be clear though, that are you suggesting, is this a new argument that those other cases did not consider?
I think that's probably accurate, Your Honor. I haven't seen that cited in any of those provisions.
Okay.
Yes.
So your constitutional argument is a new one that you are advancing in the first instance.
Yes, Your Honor, and to assist the court in analyzing the scope of the waiver of immunity of 271.152. So.
And can I ask a follow-up question about how we're defining the term extra compensation? Am I understanding the dispute is Garland ISD says we reduced the full contract amount by the amount of the liquidated damages, arriving at a lower amount, which is the full amount due and owing, to the extent that Reader is asking for the full initial contract amount, that would be extra compensation. Is that what you're saying? Or you're saying Reader's actually asking for more than the full contract amount?
Well, they're asking for more than the full contract amount because, Your Honor, because as you'll see, the contract is written to be adjusted upward and downward, depending on the circumstances. So, but I hope to.
But I guess that's my question.
Yes.
Like, if the contract's own terms specify differing amounts, that wouldn't be extra compensation under the Texas Constitution.
It would be, because the provision of this contract is written so that it's a maximum amount of their compensation is not to exceed a certain cost. And so it is not a fixed amount. So it anticipates that it can be adjusted. And I will address those specific provisions as we go forward.
I guess I just want to make sure I understand. You're saying we paid the full amount due and owing,
yes,
which is the amount reduced by the liquidated damages. Is that right?
Yes, Your Honor, because of the way the contract is written.
And you're saying the award of the full contract amount would be extra compensation under the Texas Constitution. Is that what you're saying?
That's correct, Your Honor.
Even though it's the number that's written in the contract, you're saying that would be extra compensation.
Yes, because that's the starting point, Your Honor.
Continue.
Okay, thank you, Your Honor.
I'm sorry, I'm gonna interrupt you, Mr. Henson, before you get going on the particular contract provisions, because I believe this is a preliminary question that I believe I must be misunderstanding. I want to help. I want you to help me clearly understand.
Yes, sir.
My what must be a misunderstanding. My misunderstanding is that you appear to seek for this court to construe, and the district court to construe the contract, to consider its terms and provisions, and to decide whether anyone has breached or not, or whether someone is entitled to damages or additional monies or not under that contract, pursuant presumably to that which is allowed under 272.152 in the context of a plea to the jurisdiction. My understanding of a plea to the jurisdiction is I don't care what the individual contract says or not. If there's a contract, you've got 272.152's waiver of immunity, subject, of course, to the limitations of Article 3, Section 52 of the Texas Constitution. But as I understand your argument, you've raised three issues: change orders, invalidated liquidated damages, and delay damages, all of which presumably arise out of a contract, the contract at issue in this lawsuit. And if we have jurisdiction, if we don't have jurisdiction to construe that contract, aren't you asking? I mean, it seems to me what you're asking us to do is exercise our jurisdiction in construing the contract to find that we lack jurisdiction. So you're asking us to exercise jurisdiction to find that we lack it. And and so that seems to me that I understand you want to win however you can, but it seems to me that you're trying to win at the plea of the jurisdiction phase when your argument really is a merits of the breach of contract case. Help clarify my misunderstanding.
The misunderstanding is that it is at this stage, at a plea to the jurisdiction stage, is a matter of pleading a breach Correct. And then a matter, if there's a challenge, and evidence that's put on in the plea of the jurisdiction, they are, then the party bearing the burden of proof is required to put on some evidence of its, to create a fact issue as to the plea of the jurisdiction. So,
well, there is a fact. You have conceded in your argument in here today. You have said we're arguing about what the contract says and what the contract requires, and that's clearly waived. I think, and all the cases seem to say that if we're talking about a written contract, if a local government entity that's authorized by statute or constitution to enter into a contract and enters into that contract, subject to the subchapter, waives sovereign immunity to suit for the purposes of adjudicating a claim for breach of the contract.
right.
And it sounds to me that your three issues are we didn't breach or they breached or whatever. And that doesn't sound like jurisdiction talk to me. That sounds like merits consideration.
Well, I understand. And in the, in early on, you may be considering the City of Mesquite versus PKG case, where that was the totality of the analysis. And in that case, in a lot of cases that cited it, that there isn't a contract, it's for services signed by the parties, and that's all you need, and then there's no other consideration. When that decision was made, it did not have the benefit of 22 years of jurisdictional analysis. Remember that in 2000, up until 2000, before Bland versus Blue, it was strictly a case in a plea to the jurisdiction where you couldn't consider evidence. And so since that time, through a series of cases that happened after PKG Industries, including State versus Lewick and Mission versus Garcia, and many other cases, the analysis has become that you determine whether or not they have pled the prima facie elements of the case. And if so, and if challenged on an evidentiary plea to the jurisdiction, whether they have actually met their evidentiary burden. If we put forth some evidence saying you haven't pled facts that bring your case within the waiver.
No one appears to be disputing that you're fighting about what the contract says, right? I mean, you're on notice. They're talking about the contract. You began your argument with there are three issues under the contract.
Yes.
So
I'm not disputing the existence of a contract. I'm simply stating that there's no breach of the contract. And that is a primary prima facie element of the case.
So why do we consider that? Why do we consider whether they're going to win or lose on their breach of contract?
It's not really whether they win it's not really whether they win or lose. It's whether they can plead it and put on any evidence to create a fact issue as to one element of it. Keeping in mind that the primary reason for governmental immunity is to protect taxpayer money. And so that's what's happened in the Supreme Court cases as they've gone through. And that's why Zachary rebuffed the City of Mesquite case, because it was not a full telling of the requirements stated in City of Mejia versus Took. It understated the full test. So it wasn't wrong to the extent that it stated the first elements, but it didn't state all of them. And so
it seems to me that Garland is saying there's only a waiver of immunity for a breach of contract. But since Garland says we follow the contract, the end, there's no waiver of immunity. And Reader says, well, wait a minute, here's a bunch of facts about why we believe we're owed more money under the terms of the contract. And you say, well, we said we followed it, so the end. Is that your argument, or?
No, Your Honor. Actually, I'm going to show you their evidence proves that we did comply with the contract. So,
well, we see that, and that this is where I'm hitting. This is where you're losing, because what I hear you say is, yeah, but we didn't breach. But that's not the question that a plea to the jurisdiction is about. You make the argument that Zachary appears to, and I see you look at that. You appear to take the position that at the plea to the jurisdiction phase, we decide whether there's, we decide the merits of the dispute. And you're losing me there.
Yes,
Help me get around that. Help me get around that.
Well, the waiver of governmental immunity is not for compliance with the contract. It's for breach of the contract. And so whether they are actually able to carry their burden of persuasion at trial. That's not really on issue here. It's did they plead the necessary elements, and did they, when challenged, did they actually provide any evidence to create a fact issue? And so that is not deciding the merits of the case. It's simply determining whether or not they've, as a matter of law, pled a case that fits within the waiver of governmental immunity for the breach of the contract. The case, so when we construe it, we have to remember that the legislative enactment has to be construed consistent with the Constitution, and that the waiver of governmental immunity comes through 271.152. So as I said, we have to construe that so as not to conflict with the constitutional provision I discussed. So only the legislature has the power to waive governmental immunity, and it must do that by clear and unambiguous language. And so I'm going to first talk about these potential change orders, because that's the backdrop for the legal backdrop for these cases, and you'll see how these all fit in to the case. So at CR 1148, Reader provided its final pay application in the record, and that states the original contract sum was $12,794,000, and there is a change order that's reflected in there that was approved prior to that time of $143,385. So the adjusted contract sum after those approved change orders were $12,937,385. The contract contains provisions that require the adjustment, or there's agreed upon adjustment of the contract. And so that's one adjustment up. You have a change order, can adjust it up. A change order could adjust it down as well. Also at CR 1148, there is a reference to $6,359, which says it's unfinished work, but the undisputed record, and Reader won't dispute this, is that it was for unused contingency. And so the contract requires a deduction of that. Then there was $844,116.94 in liquidated damages.
Can I ask a question that wasn't
Yes,
clear to me after reading all the materials?
Yes, Your Honor.
There was times that you talked about the change orders being unsigned, and then there were other times where it was talked about being unexecuted. And I think there was some mention of some of the change orders or CCEAs were signed by a Garland ISD employee, but maybe just not executed by the school board. Help me understand, were they totally unsigned by Garland, or they were signed by a Garland staff member and just not executed by the school board?
As it turns out, the evidence makes it irrelevant. And here's why, Your Honor. It is that they're adjusted.
I mean, I still would like to know the answer, though.
Oh, yes. Well, the person did not have the authority to
so they were signed by a Garland employee, but they were not executed by the school board.
It wasn't a change order, right? It wasn't a change order. So, but those amounts. So we had an adjusted contract sum of $12,086,909.06. That's by Reader's own evidence. GISD actually paid $12,152,807.06 to Reader. And so we paid them $65,898 more than the contract sum. And when you look at the potential change order claims, they total $65,898. So the legislature did not waive governmental immunity so that somebody could recover twice for the same work they've been paid. In their own evidence in CR 1149 and CR 800, which is evidence that they submitted, proves that. So there really isn't a PCO claim. The liquidated damages claim is a claim where they've come to the court as a breaching party. We are not in breach of that provision of the contract. This is really where the constitutional provision comes into play. And this is because the constitutional provision, it prohibits us from paying somebody more once contract performance has begun. This is if it seems unfamiliar.
And we're short on time, so I want to jump right to the question.
Yes.
You're saying they're breaching because they're the ones that didn't find the conduit before they were digging and they damaged it.
That's
Their
separate
position.
claim. That's
Okay,
a separate one than liquidated damages.
Their position is your architect didn't put the conduit that were on the as-built drawings you gave your architect. It was the architect's mistake, and we can't drill a pier through conduit. And so then they're saying that you caused the owner caused the delay, or the architect or somebody.
So,
and so there is a fact issue about whether they're not entitled to more of that money or not.
No, Your Honor. And that's because one, the evidence that they put on at CR 1012 includes the letter from VLK Architects, which includes the provision of the contract, which says that they were responsible for locating those lines, and also that they were not entitled to rely on the engineer's plans. But even more specific to the jurisdictional objective fact here is that they failed to file, if they had carried their they've pled waiver. They've more or less capitulated to the idea that they did not follow the claims processes, which are enforceable under 271.154, which state that if they're not strictly complied with, those claims are waived. And so that is the adjudication procedure for those claims. Delay damages can only exist for active interference. They are supposed to, under the contract, they agreed to do this, provide us with a written notice that specifically lays that out. Your Honor, I have run out of time.
So I have a lot of questions about that issue, and I will talk to you about that during your 5 minutes. But
Yes, Your Honor.
Specifically, so everyone's ready, you're saying because the statute says adjudication procedures are enforceable, that means that it implicates subject matter jurisdiction and immunity. So I want both sides to kind of address that argument, but we'll go to Appellee.
Yes, Your Honor.
Thank you, Your Honor. Good afternoon, and may it please the court. My name is Luke McMahon, and I represent the Appellee Reader General Contractors. Your Honors, Appellant is asking this court to do two things in this case, which we respectfully submit and ask it not to. Number one, Garland is asking this court to be the first court ever to interpret Chapter 271 of the Texas Local Government Code, or really any other similar immunity waiver statute, as barring a claim to recover improperly withheld liquidated damages based on a contractual provision that is void and unenforceable under Texas law for public policy reasons. This argument has never been raised by a party or addressed in a majority opinion, at least that I've been able to find, and I searched high and low for it. It was directly addressed, however, sua sponte, by Justice Boyd in the 2014 Zachary case in a footnote to his partially dissenting opinion, where he explained why he agreed with the majority on its decision with respect to the liquidated damages series of determinations in that case. Although Boyd's comments may not be binding on this court in a stare decisis sense, we respectfully ask the court to consider them as highly persuasive and submit that they reflect the proper way to evaluate the immunity issues that Garland's raised under Chapter 271 with respect to this liquidated damages claim. Number two, Garland is asking this court to reverse its prior holdings in City of Mesquite versus PKG from 2008, Romulus Group from City of Dallas from 2017, and then from July of last year in Texas Association of School Boards Risk Management Fund versus Greenville. And Garland would have this court instead hold that under Section 271154, a showing of compliance with contractual notice provisions, or to Justice Miskel's question earlier, adjudication procedures, is in fact required to establish a waiver of immunity under 271. This court, the Fifth Court of Appeals, and most other intermediate appellate courts in Texas hold that such a showing is not a jurisdictional requirement under Chapter 271. On this basis alone, the court may properly reject all Garland's jurisdictional arguments based on contractual notice provisions, which Your Honor's question related to just a second ago. Even if this court were to decide to somehow change course and follow the Corpus Christi court in its reasoning from the Mission Consolidated versus ERO case. The result is the same because Reader has created a fact issue on not only its compliance with any applicable notice provisions, but also on the various defensive theories that it's asserted against their enforcement. Number one, that Garland waived or is stopped from asserting them. Two, that one of them, the 14-day notice requirement from 15.1.1 of the general conditions, is void under section 16071 of the Remedies Code. Three, that their performance was excused, which invokes a separate analysis. That Garland relinquished its ability to rely on those notice of claim provisions because of its prior material breaches. All these defensive theories to the enforcement of contractual notice provisions, even if you follow Corpus Christi's reasoning, that's what the jurisdictional evidence needs to create a fact issue on, not just compliance. Now, because all of the jurisdictional evidence that we submitted really is only relevant in the event that this court decides to change course on the issue, I don't intend to spend any of my time walking the court through it. If you want to see it, it's collected at pages 12 to 15 in the response to the jurisdictional plea that we filed in front of Judge Moore, clerk's record, page 784 through 87. And then I think the better recitation of all that evidence is probably an Appellee's brief from pages 30 through 39. Now, because it was most of the focus of Appellant's reply brief, I want to start with what Garland has called our liquidated damages claim. And the first point there is really that calling that claim by that name is a little bit of a misnomer and misrepresents really the procedural context in which Reader's penalty challenge to the enforceability of the LD or the liquidated damages that were withheld fits in. Reader's claim alleges a breach of Garland's payment obligations under the contract. It's really quite that simple. Now, Garland's defense to that claim is not, we short paid you $850,000. It's, we know we did, but we were entitled to withhold that money based on a contractual provision that allows us to do so based on liquidated damages that we assess. As I briefed or tried to set forth in the surreply brief I filed, that's the affirmative defense of offset. Now, in the trial court, Garland sought to avoid discovery that we targeted to prove up that penalty challenge on the basis that, well, we haven't asserted that affirmative defense, and so that's not relevant. You can't get that discovery. To get around that, we amended our petition, and I asserted a discrete breach theory that articulated the penalty challenge that underlying breach claim really rests on. But this does not change the nature of our underlying claim. It's still a non-payment claim alleging a breach of Garland's payment obligations under the contract that seeks, and this is important, the balance due and owing under the contract, which is language that's used in 271153. The need to overcome an asserted contractual defense to a payment obligation does not convert a claim asserting a breach of that payment obligation into anything else. And there's no authority for the contrary proposition. Now, even if overcoming a defense to a payment obligation involves a challenge, like it does in this case, admittedly, to the validity or enforceability of the contractual provision that offset defense is based on, my claim still asserts one sounding in breach of contract. And contrary to some of the arguments that were raised in the reply brief, the fact that Reader's breach claim in part seeks a determination of the validity or construction of a provision under the contract, which is language you'll see in the Uniform Declaratory Judgment Act, the fact that it rests on such a determination does not convert it into some sort of standalone deck action claim that can only be pled under Chapter 37. Almost every breach claim involves, on some level, a question of the construction or validity under a contract and a determination of the party's rights thereunder. 37.
How else do you resolve a breach of contract case?
Beg your pardon?
How else can you resolve a breach of contract case?
Well, that's our point, Your Honor. And really the big issue is that, and there are legal doctrines that have developed, that the redundant remedies doctrine that acknowledges that oftentimes parties will plead a deck action that really mirrors their underlying breach claim. And those doctrines don't disallow the mirrored declaratory relief under 37 from proceeding. What they do instead is limit the ability to recover, for instance, attorney's fees under Chapter 37, when my deck action claim really adds nothing and instead mirrors my valid breach of contract claim. And the point there is that even though a breach of contract claim involves, at least in part, a declaration of rights or that issue hook under Chapter 37, it does not need to be pled under Chapter 37. The MBM case that I cited on page 10 of the surreply brief that we filed gets into that a little bit. And a couple other cases I cited stand for this proposition. Although a post-breach deck action claim can look a lot like a breach claim and really mirror it, the difference is that a breach of contract claim seeks both a determination of liability and an award of damages, whereas the declaratory judgment claim seeks only a determination of liability. And maybe, Justice Peterson, that more directly answers your question. What differentiates the two is that our breach claim seeks an award of damages in addition to a finding of liability.
And you're, if I understand the state of the pleadings, you are at this time not seeking a declaratory judgment. Is that correct?
Correct. Now
you did, but then you've abandoned it. Is that accurate?
No, that's not right. What we've done is we've anticipated Garland's assertion of the offset affirmative defense based on the liquidated damages provision. The way that you would defeat that as the party asserting the non-payment obligation is you've got to still assert your penalty challenge to its ability to rely on that unenforceable provision. And so what I did so that Judge Moore would grant our motion to compel is I amended to put that issue before the court and affirmatively allege the penalty challenge as kind of a discrete breach theory, which really it's not though. That was for purposes of getting that motion to compel granted. The Zachary case is instructive on so many issues before the court. In that case, Zachary sought to recover over $2 million in liquidated damages the port had withheld based on an almost identical withholding clause to the one Garland relies on. Now, at the trial court level, Zachary alleged that penalty challenge, and the trial court granted it or found in its favor, found that that provision was unenforceable, and directed a verdict, in fact, partial directed verdict on Zachary's underlying breach claim that sought to recover those improperly withheld liquidated damages funds. Now, the port never challenged that finding on appeal. Instead, the way to pose that recovery was it said, well, that may be the case, but in all of the payment applications that you submitted throughout the project, you released all your rights to unpaid work that was subsumed within those payment obligations. So the port actually opposed that relief by relying on release language in those payment applications. And that's the issue throughout the appellate chain that the courts addressed. The port also did not raise the challenge that Garland does in this case, that somehow Chapter 271 somehow bars or does not waive immunity on a claim to recover improperly withheld liquidated damages. Now, Justice Boyd he disagreed with the part of the majority's opinion on the other issue related to the delay damages. But in footnote 1 of that dissenting opinion, he drops a footnote where he wants to make clear that, well, I agree with the majority on the liquidated damages issue. And even though no party or the majority opinion had raised the issue of sovereign immunity, he speaks directly to it. And what he says is, I'm going to quote this one important sentence: the funds withheld as liquidated damages by the port were a part of the payments that it agreed to make for Zachary's services, and accordingly were part of the balance due and owed under the contract, which is that language from 153 again. And he went on to say, 153 thus waives the court's immunity from suit against Zachary's claim to recover those funds, and the courts have jurisdiction to resolve that claim. Now, nobody had raised that argument, and it's probably dicta, but it is part of the portion of his dissenting opinion where he explained why he agreed with the majority. Also, subject matter jurisdiction can be raised at any time, even sua sponte. Now, does that convert those remarks into binding authority with respect to this court? I don't know. I'm not the appellate ace in the room, but we're not really suggesting that. As the only authority that's out there, or certainly that's been raised to the court's attention, that even directly addresses the issue that Garland makes, or the argument that it makes with respect to liquidated damages, we ask the court to find that it's quite persuasive. Another point I want to bring up is in Appellant's opening brief, there's a challenge to the $154,000 and change that we seek as compensable delay damages for what we call the concealed lines delay claim of ours throughout the briefing. And Justice Miskell, that's the claim that you were asking about earlier with respect to the architect. Now, in that case, as there is in this case, there was what we call in construction, a no damage for delay clause, some sort of limitation on the contractor's ability to recover more money for a delay that it alleged was the owner's fault. In that case, an immunity challenge was raised on that issue. Whether or not that no damage for delay clause even affected the ultimate Chapter 271 analysis, the court didn't even get there. In fact, it only evaluated whether the operation of that contractual provision barred the requested recovery once it got to the merits after it addressed the sovereign immunity issue. And the very important takeaway from that is this. When your defense to the payment obligation that I'm suing on is that you're relying on let's say a limitation for damage provision in a contract, a liquidated damages provision, or one of these no damage for delay provisions. And your argument is that I'm not seeking the amount due and owing under the contract because the operation of that provision would defeat my requested recovery. That's not what Chapter 271 asks us to determine. In fact, that countless opinions, the Zachary opinion, a case out of San Antonio that I attached as Exhibit 13 to the supplemental brief I filed with Judge Moore, that you'll actually find a copy of in the clerk's record beginning at page 1370. All of those cases stand for this proposition. When the way you want to defeat my requested recovery is to cite to some provision in the contract and argue that ultimately on the merits, it will bar the recovery I'm seeking, that's not a Chapter 271 issue, and we don't get there. In Appellant's opening brief, the main argument that I can glean against that compensable delay claim that we assert is that the operation of the no damage for delay clause excludes it or bars it. That's not a Chapter 271 issue. With the few minutes I have left, I do want to speak a little bit more to Justice Miskell, your question about contractual adjudication procedures. This court and almost all the others, except Corpus and Beaumont, find that no evidentiary showing of compliance is even required. The one case that suggested differently was Mission Consolidated versus ERO, a Corpus case from the mid-2010s, 2015, I believe. What it did is it referred back to one sentence out of the Zachary opinion that did a lengthy statutory analysis on the significance of the last clause in subsection 152 of Chapter 271. And the quoted language is, subject to the terms and conditions of this subchapter. Now, the one sentence from Zachary that the Corpus Christi court interpreted was that the significance and the meaning of that language is that the waiver provided for in subsection 152, what does it mean when it says subject to the terms and conditions of this subchapter? Well, it's referring to all the other subsections. 153, for instance, 154, which is the one about contractual adjudication procedures. The problem with that analysis was that when you read Zachary, when it frames the issues, and it does multiple times, the language it uses refers only to the claim that was, or the context in which, I guess, it evaluated the claim before it, the challenge before it. And that was under 153. What this court did in Romulus, and there's a case we've cited out of Appellant that really explains this better than I could, is we're not going to read Zachary to have impliedly overruled this court's decisions holding to the contrary under some sort of implied overruling analysis, because the issue in front of the Zachary court was about 153. It wasn't about 154. And just in July of last year, in a case that is very contextually different, the Greenville case, this court went through the analysis again. And so we don't even really need to get into the evaluation of any of the jurisdictional evidence we've proffered to get to the right result, which is to affirm Judge Moore's denial of Garland's jurisdictional plea. And for those reasons and all the others that I've tried to set forth in our briefing, because I'm running out of time, that's what we're asking the court to do. Thank you so much.
Any other questions? Okay, thank you very much. Appellant, whenever you're prepared.
And you're muted.
Thank you. Thank you for telling me. Okay, so Zachary doesn't actually address liquidated damages. It says so. They didn't raise it. It's really not authority for it. But more importantly is the analysis. And when we think about the clear and unambiguous waiver of 271.152, all of the authority that they cite is, for public policy and so on, is really based upon private interest contracts. This is a public interest contract, treated completely differently than a private interest contract. Private interest contract, you can bring any number of claims, equitable or otherwise. And indeed, in all of those cases, the courts use their equitable powers to strike down liquidated damages provisions. The idea
so hold on.
Yes,
I would like to start with the question that I teed up before, which is 271.154 says contractual adjudication procedures are enforceable.
Yes.
It seems like there's some steps that maybe skip to jump to, therefore, if we allege you didn't follow the procedure, therefore sovereign immunity was never waived, as opposed to we might get into it later at the merits. Can you specifically explain your reasoning on how the word enforceable means it's a subject matter jurisdiction issue?
Yes, Your Honor. So it goes, and so in this case, we put on evidence with our pleaded jurisdiction, stating that they did not follow those steps, that they did not comply with those procedures. Under those provisions, contractual adjudication procedures, it says that if they don't follow those procedures, those claims are waived. And so it's an objective fact whether or not they complied with those provisions. It's not equitable. It's not anything.
Okay, but you said the word fact, though.
Yes.
Which.
Yes, and they are absolutely obligated under jurisdictional analysis to provide some evidence that creates a fact issue as to a jurisdictional requirement. So yes, absolutely. The court has been doing that for.
Okay, but that's my whole question.
Yes.
Is what converts the word enforceable into a jurisdictional requirement? How do I know that if there's disputes about who did or didn't follow the procedure, then that means courts lack jurisdiction or there was no immunity waiver?
that means that in this case, there's no money due and owing for those claims because they've waived them. So,
Okay,
so
but that's all a dispute into the merits of the case.
it is
I'm trying
not,
to understand
yeah.
your argument that the words of the statute make
Yes.
enforceable
Well,
a jurisdiction issue.
That is the primary holding of Mission versus ERO. And of course, that when the Zachary said that all of these provisions are jurisdictional, when they said subject to, they didn't mince words about it. They went back and even went back to City of Mejia versus Took and said, look, even these claims for consequentials, even all of these things that had been talked about as factual issues, that was wrong. And so and they just thought in the opinion, they said, we thought we'd never have to say that, but there it is. And so that's the reason, is that those are jurisdictional. The cases that they disapproved of, or two of them were mine. One was the Roma case and one's the Santa Rosa case, where they both turned on this issue of the jurisdictional nature of these provisions. One was on consequential damages, and one was on notice procedures, and one was on contractual adjudication procedures. And the pinpoint site goes to those decisions where it talks about disapproving the PKG Industries case. So the only problem with PKG Industries was that it simply understated the jurisdictional requirements. In this case, it has to be a clear and unequivocal waiver, and it is absolutely the case that it's the public policy of the state of Texas to limit the kinds of claims and the kinds of damages that can be assessed against a school district, and the facts that need to be proven to do that. These are not on square at all with private interest contracts. For that reason, the legislature sets the public policy of the state and not the judiciary. Yes,
I'm happy you brought that up, Mr. Hanson, because I just seek to return, and we're going to go over time just a moment. I just request some accommodation. You've raised what you describe as an issue of first impression, and that is Article 3, Section 53 of the Texas Constitution and its limitations on the legislature's ability to award money in a breach of contract suit. But I don't understand how you can square what you describe as basically a new argument based on the constitutional language with the existence and continued application. And in my view, my unlearned opinion, the way that the legislature is in compliance with Article 3, Section 53 of the Texas Constitution. If you have limitations on adjudication awards, that assumes that there's an adjudication. If you have contractual adjudication procedures enforceable, all of that, in my opinion, assumes that a court has jurisdiction to adjudicate or enforce. And that's why since it's an issue of first impression, that's why I wonder if Article 3, Section 53 of the Texas Constitution is here and implicated in light of those limitations. Tell me what I've misunderstood.
Well, I don't feel like it is a case of first impression in terms of the overall analysis. I referenced the constitutional provision because of the invalidation provision of what they're seeking is to declare a provision of a bargain for public interest contract invalid. So they're asking the court to put itself in the position of a school district negotiating a contract.
No,
and it's completely different.
No, they're not. That's not at all what they're doing. They're saying there's a contract. We have an objective writing. That's why we have the statute of frauds. We have an objective writing, and a court may adjudicate awards based on that contract or enforce contractual adjudication procedures.
Well, the statute of frauds is really pale by comparison to the requirements of the waiver of immunity. And it has to be strictly construed against waiver. And it must be, as all of those cases before IT Davie and City of Mejia versus Took, and all of those cases were just, they didn't, and they construed language more broadly than it should have, Your Honor. And so for that reason, my time is up. I would just like to say that it's a very important decision, obviously, by the court. I don't believe it's of first impression However, that constitutional provision really should inform the analysis of the waiver. Thank you, Your Honor.
Thank you very much. We really appreciate excellent briefing, excellent argument. Really helped us out a lot. We really appreciate the cases submitted. Thank you so much.
Thank you, Your Honor. Thank you.
Thank you.
Everybody stay safe.
Thank you. You take care.